I've concluded that the approach of a constitutional amendment is not the best way for us to seek to deal with abortion. I believe that the legal interdicting of abortion by either the federal government or the individual states is not a plausible possibility, and even if it could be obtained, it wouldn't work. Given present attitudes, it would be prohibition revisited, legislating what couldn't be enforced, and in the process creating a disrespect for law in general. And as much as I admire the bishop's hope that a constitutional amendment against abortion would be the basis for a full, new Bill of Rights for mothers and children, I disagree very respectfully that that would be the result. I believe that more likely, a constitutional prohibition, which you can't get, but if you could, would allow people to ignore the causes of many abortions instead of addressing them, addressing the causes, much the way the death penalty is used to escape dealing more fundamentally and more rationally with the problem of violent crime. Now, other legal options that have been proposed are, in my view, equally ineffective. The Hatch Amendment, by returning the question of abortion to the various states, would have given us a checkerboard of permissive and restrictive jurisdictions. In some cases, people might have been forced to go elsewhere to have abortions, and that might have eased a few consciences here and there, but it would not have done what the church wants to do. It would not have created a deep-seated respect for life. Abortions would have gone on, millions of them. Nor would a denial of Medicaid funding for abortion achieve our objectives. Given Roe against Wade, it would be nothing more than an attempt to do indirectly what the law says cannot be done directly. And worse than that, it would do it in a way that would burden only the already disadvantaged. Removing funding from the Medicaid program would not prevent the rich and middle classes from having abortions. It would not even assure that the disadvantaged wouldn't have them. It would only impose financial burdens on poor women who want abortions. And apart from that unevenness, there's a more basic question. Medicaid is designed to deal with health and medical needs. But the arguments for the cutoff of Medicaid abortion funds are not related to those needs. They're moral arguments. If we assume that there are health and medical needs, our personal view of morality ought not to be considered a relevant basis for discrimination. We must keep in mind always that we are a nation of laws, when we like those laws and when we don't. The Supreme Court has established a woman's constitutional right to abortion, whether we like it or not. The Congress has decided that the federal government doesn't have to provide federal funding, but that doesn't bind the states in the allocation of their own state funds. Under the law, the individual states need not follow the federal lead. And in New York, I will speak only for New York, not for Indiana or any other state. In New York, I believe we cannot follow the federal lead. The Equal Protection Clause in New York's Constitution has it been interpreted by courts as a standard of fairness that would preclude us from denying only the poor indirectly by a cutoff of funds of the practical use of the constitutional right that's given to all women in Roe against Wade.